Good morning, good afternoon, or good evening, depending on where you are in the world. And welcome to Finnegan's first Asia Series webcast of 2019. Practical advice on U.S. patent law issues, opinion letters, and IPR filings. I'm Ningling Wang. I'm Managing Partner of Finnegan Shanghai office, and I will be your moderator today. It's my great pleasure to welcome our presenters, Pierre Duroux and Eric Fuse. Eric is our group leader for Chemical and Metallurgical Practice Group. He represents clients in domestic and international technology disputes, including patent and trade secret litigations and trial and appellate levels. He has also been involved in more than 50 district court matters and U.S. International Trade Commission investigations. Eric used to be the president of ITC Trial Lawyer Association, and his practice also includes client counseling. In addition to Eric, I would also like to introduce you to Pierre Duroux, who has broad experience in strategic client counseling and patent litigation before U.S. District Courts and the Patent Trial and Appeal Board, PTAB, of the U.S. PTO. He has handled every stage of litigation, including pre-litigation investigations, discovery, dispositive motions, and trials. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar, so just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window. Then click Submit. The questions will be answered today during the question and answer session if we have sufficient time, but it will take place at the conclusion of the presentation. If we cannot answer all the questions, we're going to answer your questions after the webinar by emails. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you're experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now I will turn it over to Pierre and Eric to begin our first Asia Series presentation, Practical Advice on U.S. Patent Law Issues, Opinion Letters, and IPR Filings. Welcome, Pierre and Eric. The floor is yours.
All right. Thank you very much, Ningling. This is Eric Fuse. I will present the first portion of the presentation. Then I will turn the presentation over to Pierre, and he will take the second part. Our presentation today is about opinion letters and IPR filings, and there is a definite intersection between the two, and investments in one can help investments in the other. So advancing through the slides, there really is a point when you are doing an opinion letter where you have a moment to get an early assessment of risk before the distractions of litigation. So we have two lawyers that are talking in our cartoon on slide 3, and one of them says, I consider myself a passionate man, but of course a lawyer first. And that's really because the focus of the opinion letter is on the substantive meat and potatoes of a patent case. It's on the patent claims, the specification, the prosecution history, the prior art, manufacturing information. That's very different than all the other issues that you might get in a litigation. You might have to worry about venue in the Eastern District of Texas. You might worry about the timing of submissions. Do you have a jury trial or a judge trial? Trial themes, all these additional things that you have to think about. In the opinion letter, you get to really focus in on the meat of the early issues in the case. So our agenda is freedom to operate, and then we'll talk about opinion letters in various situations, and then we'll move on to IPR petitions and IPR update information. Now, freedom to operate, why is it important? Well, it's important for a number of reasons. It confirms the ability to compete and freely market a product. You identify risks of infringement. Sometimes you want to market a product, and you're willing to accept some risk, but not a lot. So this lets you kind of quantify that. You get to identify limits in product design and manufacturing where you want to stay away from a certain area where you may be aware of existing patents. And maybe that your product doesn't really need those features, or you can manufacture the product a different way and still have a very good product for your company to sell, for your client to market. Another reason why freedom to operate is important is it gives us preemptive avenues for challenging other companies' patents. You can challenge another company's patent without being in litigation, for instance, if you want to file an IPR. So sometimes if there's a blocking patent or something that causes great difficulty for your company, you can file an IPR on that, and the opinion letter will give you a head start on that. And very importantly, opinion letters document the good faith belief of a company in non-infringement or invalidity that years down the road can help protect against allegations of willful infringement and enhanced damages. So in short, freedom to operate analysis helps you reduce uncertainty and manage risks.
And Eric, why is willful infringement a particular concern for a defendant in a litigation?
Well, there are a couple reasons. One of them is that willful infringement can result in up to triple damages under United States law. Another reason is that if there's a finding of willfulness, it can increase the likelihood that the court, because of the other found facts that relate to willfulness, could also determine that it's an extraordinary case and grant attorney's fees. And on top of that, there's always the worry in a jury case, if there's so much willful activity at the discovery stage that the patentee is aware of, then that could conceivably taint the jury's opinion of a party, and maybe they won't pay as much attention as they need to the specific facts that relate to infringement. In other words, they might be less objective if they're shocked by what they learn. So questions about when to analyze, when to look at freedom to operate. You can look at that before you have a major R&D investment, before you start a new product line. Right when you're preparing to launch a new product, you could have a second search for patents to see if there are any issues. Many companies are aware of their competitors' patents. So, for instance, you may have been tracking notices of allowance at the United States Patent Office. You may be looking at WO patents and are aware of a U.S. filing, things like that. So it helps you prepare for when those patents come out and when those competitors eventually potentially send you a letter saying, hey, I want you to be aware of my patent. When you're entering into a new market, there are a host of reasons when to analyze freedom to operate in connection with your companies or your clients' companies. So some of the best practices, and this is really key, the timing of when you learn of a potentially adverse patent is when the clock starts ticking for willfulness purposes. So in cases again and again, and we'll see some of this later on, the courts look at when a company had notice of a patent, and then they look at what happened around the time after they had notice. They don't now, as we'll find out, the case law has changed. They don't wait to look at the frame of mind when litigation starts. They are much more interested in what happened earlier on. So the best practice is that when someone becomes aware of a patent, they should try to study it and try to see if they can develop opinions about that early on. Of course, for best practices, you're going to look at invalidity and non-infringement defenses, and you're also going to try to document these steps so that later on, as I had an evidence professor say, you have footprints in cement where you have evidence that you can look back on and see what happened potentially many years ago.
Eric, how is an opinion letter functionally used in litigation to defend against willfulness allegations?
So an opinion letter is a communication that a company or client has with its lawyers. It's a privileged communication. But to document the good faith of the company, at some point during the litigation, a company can say, I want to rely upon my opinion letter that I received from competent counsel and show that I was serious about trying to avoid infringement or that I thought the patent was invalid. And at that point, you can turn that opinion over to your adversary in the litigation. Usually that's far, far down the line, but that is when you would use it. Sometimes, for instance, an interrogatory is given to you or propounded on you, and it says, are you going to rely upon any opinions of counsel in a defense against willful infringement charges? And when you answer that interrogatory before the deadline, if you're going to rely upon the opinion of counsel letter, you need to update the interrogatory and tell the other side about it. So attorney-client privilege concerns is something that we just touched on just a moment ago. The reliance on an opinion of counsel letter will waive attorney-client privilege, at least as to the subject of the opinion letter. I mean, you're giving the letter to your adversary, so you are going to give that aspect of your privilege up. There has been litigation, including en banc cases at the Federal Circuit, where relying upon an opinion letter will waive communications between opinion counsel and the client, but not necessarily between the client and trial counsel. So sometimes the courts build a bridge there. And in fact, in Seagate, they said in general terms, the trial counsel's attorney work product and also attorney-client privilege communications with the client are not waived. But there are exceptions. There are always exceptions to this, and it depends upon the circumstances and factual issues that underlie that particular litigation. You know, was trial counsel always acting as trial counsel, or were they also acting in a different way earlier? Things like that. You know, if you really step back and think about it, attorney-client privilege is something that you want to protect, but you also want to protect the company from charges of willfulness. That's very important too. So it's a balancing, and it's not the end of the world to turn over an opinion letter if it saves the client or the company a lot of money and helps them rebut a charge of willful infringement. There are some things proactively, some activities proactively that can be undertaken to avoid unnecessary waiver of privilege or just avoid problems that you might have later on in the litigation itself, just by taking a little bit of time ahead of time to be careful. One of them is avoid mixing litigation correspondence with opinion correspondence. The client, the company, should keep those separate. The correspondence with opinion counsel on invalidity or non-infringement should be factual, strictly factual. You can say our process operates in the following manner. We found the following prior art we'd like you to look at, things like that. But don't, embellish what needs to be just a simple, factual, short communication, because later on, any of the ways that you attempted to embellish that communication can come back and be used potentially against you in litigation. Similarly, avoid patent profanity. You don't say this is our best argument, this is our second best argument, this is our third best argument. Simply talk about the prior art, how the manufacturing process works if you're talking about non-infringement, things like that. Another way to kind of protect the area that will be disclosed if and when the opinion is relied upon is to use an outside search firm to conduct the invalidity searches. That would mean there are fewer discoverable documents at your client's side that need to be turned over to opposing counsel. So opinion letters when anticipating litigation. On our slide 11, this is an important slide. It shows two different provisions of the United States Code that talk about opinion letters, and, well, they impact opinion letters. And they seem to be in a little bit of conflict, a little bit of tension. On the left-hand side of the slide, we say that when damages are found, the court may increase damages up to 3 times the amount found or assessed. So that's what we talked about earlier about enhanced damages. On the other hand, there's another provision of the code which came into effect 8 or 10 years ago. It says the failure of an infringer to obtain the advice of counsel with respect to any allegedly infringed patent, or the failure of the infringer to present such advice to the court or jury, may not be used against that accused infringer to prove willfulness or even to prove inducement. So the left-hand side of the slide is saying what can happen, but the right-hand side is essentially drawing a line and saying that you don't have to have an opinion letter. But on the other hand, you need to step back and think to yourself, well, if I don't rely upon an opinion letter, what am I going to rely upon to rebut a charge of willfulness? In preparing for this presentation, I looked at a few statistics, and it jumped out at me that in approximately 92% of the cases that are filed in the federal district courts that involve allegations of patent infringement, willfulness is alleged. That means in 9 out of 10 times, the patent owner is going to say that you're a dirty, rotten scoundrel, that you're willfully infringing their patent. They're going to use words like bad faith, deliberate copying, characteristic of a pirate. They're going to say all kinds of terrible things about your company or your client. And they're doing that because they want the court to indeed give them 3 times their damages. So there have been changes in the law, we alluded to this earlier, about opinions of counsel and willfulness. In 2007, the Federal Circuit fashioned, it's actually kind of interesting, the opinion, because it was only a small part of the opinion that discussed these particular points. The rest of it was about privilege. But in 2007, the entire court sitting in bank had developed and adopted a two-prong test. And the first prong was the hard prong for the patent owner really to prove. And it was to prove that the accused infringer acted despite an objectively high likelihood that its actions were infringing. That's called the objective prong. And then only if you jump past that hurdle did the court look into whether or not the risk of infringement was known or so obvious that the infringer should have been aware of it. So the first prong, called the objective prong, meant that at that time, in 2007, as long as you had a good argument in court, even though it wasn't a winning argument, but if it was objectively a good argument, the entire analysis stopped there, and there was no chance that you were going to be found to be a willful infringer. The law has changed. That was kind of one end of the spectrum, and now it's come back. And the law changed in a Supreme Court case in 2016, which essentially reversed the Seagate test for enhanced damages, said it was unduly rigid. And here's that language that the court used to describe when willfulness was appropriate. It was for the wanton and malicious pirate. And the Supreme Court in Halo was trying to avoid the situation where the wanton and malicious pirate was knowing all along that the patent was valid and infringed, but hoping to essentially hire a clever lawyer so that by the time they got to trial, that lawyer could make at least a good enough argument to go past to satisfy the objective prong. In other words, to stop the willfulness analysis, because even though their argument didn't win, it was objectively okay. So the Supreme Court got rid of the objective prong, and now it's changed the focus back to a focus essentially on the state of mind of the alleged infringer. So the new test, it studies on the egregiousness of the defendant's conduct. The most relevant time frame is when infringement occurs, and timing really does matter now because, and the Halo Court actually went into this, parties can't wait now until litigation to develop defenses to avoid willfulness charges and enhanced damages. The state of mind when the infringement begins is what matters, and that necessarily in almost all instances is before the litigation starts. The courts have stepped back in time to looking at kind of the facts and circumstances test. A very famous case is the Reed versus Portek case from 1992. It lists a series of 9 different kind of factual inquiries that courts can look at to determine whether or not willfulness has occurred, and also whether there should be enhanced damages. And this means that all these factors are subject to discovery, meaning that patentees are going to try to gather information about all these things during fact discovery so that they can later make a presentation at trial. You should understand that the way courts work and the way the litigations work is that the jury, if it's a jury trial, will find the facts and essentially find willfulness, and then it shifts to the judge to decide whether that willfulness should result in enhanced damages. That's precisely why in the statute it said the court may award up to 3 times damages. The judges have some discretion there.
Eric, what level of detail or analysis should parties be putting into opinion letters in order for courts to find them effective for rebutting willfulness charges?
Well, we don't have it on the slide, but essentially in the Reed case, it also talked about what goes into a bona fide, good faith, serious opinion letter. And some of the things that the courts talked about is you need to have a full analysis of the specification and the claims. You need to talk about the prosecution history to the extent it relates to claim construction issues. In other words, you need to go through essentially the factors that a district court would look into for claim construction, and then you need to apply that claim construction either against your prior art or against your process if you're trying to show non-infringement. Now I'm going to move a little bit quicker because I need to be able to turn the presentation over to Pierre, but we have a couple cases here where the Federal Circuit has essentially found that the analysis was insufficient by the accused infringer and their lawyer, or they didn't even do an opinion of counsel, and then they, in fact, got tagged with willful infringement. So in the Georgetown rail equipment case, the Federal Circuit affirmed the district court's consideration of the Reed factors, which we just looked at on the prior slide. The district court noted that the defendant really didn't form a good faith belief of invalidity because it didn't conduct any investigation into the asserted patent when it first became known. And then later on in litigation, it simply asserted that each component of the claimed invention was separately known in the art. Well, as many, many patent lawyers know, and I'm sure all of our audience knows, patents routinely include things that are known in the art plus combinations that aren't known in the art. In other words, it's the totality of the patent claim that matters. It's not each individual component and whether it's separately known in the prior art. So in Georgetown rail equipment, the defendant definitely would have benefited from an opinion of counsel letter that applied the correct principles and in fact looked at the proper test for obviousness rather than just this test about, or these comments about things being separately known in the art. Another example is the Arctic Cat case. Here the defendant, according to the Federal Circuit, conducted only a cursory analysis of the patents. And then they waited years before seeking advice of qualified and competent counsel. And here they awarded that the district court had awarded triple damages, and the Federal Circuit affirmed. Now, the next 2 cases are 2 district court cases where, for the accused infringer, the outcome was better. And both of them focused on the fact that the accused infringer had gone out and done their due diligence and had gotten opinions of counsel well before the litigation. So in the Great Batch case, the defendant obtained invalidity and non-infringement opinions before litigation. The jury found willful infringement, remember, based upon those facts that I mentioned to you, but the court declined to enhance the damages. In other words, the court used its discretion and said, we're not going to enhance damages. Important to the court was the fact that the defendant had a good faith belief that it didn't infringe. That good faith belief was proven wrong by the jury verdict, but it had a good faith belief years ago when it studied the issue. And one of the important reasons was that an opinion of counsel had been obtained by the defendant, when it learned of the patents at issue. Another case is the Loggerhead Tools case. And here, the defendant consulted with an attorney before litigation to develop invalidity and non-infringement opinions. And the court, in fact, in granting summary judgment of no willfulness, actually had focused on the fact that to confirm non-infringement, the consultation had been conducted with the attorney throughout the course of designing the product, and the court found that to be highly probative evidence of good faith. Now, the last topic is a little bit more of a nuanced area to go into. This is opinion letters during litigation itself. It's always our view that that if it's possible, it's better to get an opinion letter earlier on, but it's not always possible. So there are instances where a post-case filing opinion letters could help establish a good faith belief in either non-infringement or invalidity and help militate against the risks of a finding of willful infringement. This is because under the HALO standard, which we talked about, the patentee needs to show that the defendant knew or should have known that they were infringing. But an independent post-filing opinion could be used to bolster a good faith defense regarding non-infringement or invalidity, particularly in the situation where a patent issues on one day, and then on the second day, the patent owner turns around and sues your company or your client. Sometimes there's not enough time between patent issuance and litigation to go out and get the opinion. So that's the situation where you could attempt to use a post-filing opinion letter, just like you could undertake other remedial acts post-filing, such as ceasing to manufacture a certain product until the litigation is decided and things like that. So just to summarize, we recommend seeking opinions of counsel in the best case before even a complaint is filed. Where there's limited or no prior notice, we likewise recommend seeking opinions of counsel after complaint filing. This is because at the end of that 2.5 or 3 year discovery period and fact discovery period and pretrial schedule and everything else, there's going to be facts about what happened early on. And to show that the accused defendant immediately went out and sought independent opinions of counsel, and they have documented filings and tried to act as a good faith company to avoid infringement, those are facts that can be used later in the trial to try to defend yourself. So if you get a cease and desist letter, that's the best time to get an opinion letter. But if that's not possible, you can also try to get an opinion letter soon thereafter, not waiting too long like we saw in those prior cases, and try to use that as also some evidence of good faith. So with this portion of the presentation concluded, I will turn the presentation over to Pierre Deroux.
All right, thank you, Eric. We will now move on to IPR petitions, and we have some statistics to share. But first, to build on what Eric has discussed, a strong opinion letter really can do double duty for a company. What I mean by that is that an opinion letter, once it's prepared before litigation, can help rebut potential willfulness allegations in a future litigation. But once the opinion letter is in place, it can also form the starting point for a nice strong IPR petition or CBM petition or PGR petition. And the reason is that an opinion letter provides the opportunity to develop strong positions based on analyzing the prior art. And going through that process allows a company to evaluate the strength of its arguments for unpatentability. And so with a strong opinion letter in place, a company, for example, can be in a good position to quickly file an IPR petition in the future if litigation ensues. And there are benefits to filing IPR petitions early in litigation if possible, because it provides an increased chance that the district court may stay the litigation until the IPR proceeding has run its course. In addition, there can be other strategic changes that companies face where they may have a need to file an IPR petition relatively quickly. For example, there can be large R&D investments that are coming down the pipeline. There can be new product launches. There can be new competitive threats from competitors that advance the time frame for a company to obtain more certainty with respect to its patent risk. So as one example that we've handled in the past, companies sometimes will find that an opinion letter is sufficient for a certain period of time, maybe for a few years. But if the company is looking to launch a new product that could potentially infringe, or if they are deciding whether or not to build a new plant in order to manufacture a new product that is a very large investment, perhaps an opinion letter does not provide quite as much certainty as the company would require in order to make those investments or to launch that new product line. So in those situations, it can make sense for the company to try to obtain greater certainty by filing an IPR petition to take out the patent, because if there's no valid patent, then the infringement risk can go to zero. I'll also note that having opinion letters in place can also put a company in a good position to evaluate positions for filing PGR petitions. These typically need to be filed within 9 months of patent issuance.
So, Pierre, I have a question for you. And in preparation for this webinar, several people had asked about the production of an opinion letter by a petitioner in an IPR proceeding. In other words, does the opinion letter need to be produced in the IPR itself? Can you please answer that question?
Yeah, certainly. Opinion letters are generally covered by the attorney-client privilege, and they remain privileged and not disclosed typically until they are actually relied upon in a district court litigation. So they typically are not produced during the IPR. Now, I will note that there is an obligation in IPR proceedings to disclose information inconsistent with positions taken in an IPR, but there is an exception for materials that are covered by the attorney-client privilege. So a company does not have to disclose other documents that it has prepared with its attorneys, just in general. And in addition, hopefully, any opinion letter would not be inconsistent with positions taken in a later IPR proceeding. The idea and the best practice is really to maintain consistency between a litigation, between IPR proceedings, PGR or CDM proceedings, and also when preparing opinion letters. So we do have some updated statistics from these proceedings before the PTAB. These generally include all of the IPRs, PGR, and CBM filings. And within fiscal year 2019, so that I believe that's roughly October of 2018 through today, we can see that there have been 688 total petitions filed, and the vast majority of them are in the electrical or computer space with 62%, or in the mechanical and business method patent space with 23% of recently filed petitions. In the chemical and bio and pharma space, those combined make up about 15%. In design patents, there have been only 3 petitions filed, and I think this data is through February of 2019. So the trend continues to show that most petitions are challenging electrical or computer patents or mechanical and business method patents. We also have an update on institution rates by technology area, and in the first 2 bars, we see that the institution rates for the biopharma and chemical spaces is 59% and 63% respectively. These are generally referred to as the unpredictable arts and at times, and therefore the institution rates seem to reflect this because they're a little bit lower than in the electrical and computer space and also the mechanical and business method patent space. Those institution rates are higher at 68%. For design patents, you can see by the total number of institution decisions, there have been 43 such cases analyzed. Those institution rates are lower, but these challenges to design patents are comparatively rare. And then we also have the trend shown here on the screen of institution rates over time since the beginning of IPR and AIA proceedings. You can see that the trend has been that the institution rates have been decreasing over time. They started very high at about 87% in the first year, and you can see the number of filings went up rather dramatically from 2013 through 2015, and then the numbers have been relatively stable in terms of total petitions filed, but then the institution rates have been going down with an institution rate of only 60% in 2018. Just in the last year, in fiscal year 2019, it's important to remember that we only have a partial year of data, but it looks like there has been a little bit of an uptick in institution rates, back up to 65%. So whether this means that rates are stabilizing or maybe they will continue to decrease, we'll just have to wait for the full year.
All right, Pierre, I've got a quick question for you on slide number 26. Your data show that there are about 1,400 to 1,500 petitions per year in the last several fiscal years. How does that compare to the number of opinion letters in your estimation?
Well, Eric, the IPRs make up the vast majority of these filings. And IPRs can really only address patent invalidity in two ways. And it's based on anticipation under Section 102 and obviousness under Section 103. And IPR proceedings are based on printed publications as the prior art for asserting unpatentability. Now, opinion letters, in contrast, can rely on more bases of invalidity. For example, they could rely on patent subject matter eligibility under 101, or written description or enablement under Section 112, or they could be related just to non-infringement. And so I would expect that there would be many more opinion letters than there have been IPR, PGR, and CBM petitions. And one upside for petitioners is that if they survive the institution hurdle, the rate of canceling a claim in a final written decision is fairly high. And so in this slide, what we've shown is the instituted claims that are found unpatentable. So in 19% of cases, no claims are found unpatentable, and that means that all of the claims survived. In 18% of the cases, some claims survived and some claims were found unpatentable. So if you're a petitioner, this is still a victory if you get the claims that you need to avoid infringement allegations found unpatentable. And then in 63% of the cases, all of the instituted claims have been found unpatentable. And so once a case is instituted, a petitioner is in a fairly strong position to prevail in an IPR proceeding. Now, I would like to circle back to opinion letters and just the reasons why it is helpful to carefully develop and document invalidity positions in advance. And the reason is that preparing an IPR petition will benefit from a company's investment in the time and energy to conduct some due diligence and to document those positions. And one reason is that the petition really should be strong enough to withstand the patent owner's arguments throughout the entirety of an IPR proceeding. So we have a case here from the Supreme Court known as the SAS Case. And as the Supreme Court has explained, the petition really is the centerpiece of the proceeding, both before and after institution. And the board has an obligation to address every claim the petitioner presents for review in its final written decision. And now, if we consider the timeline for an IPR proceeding, the petition really stands alone for about 1 year before the petitioner has its next filing as of right in the proceeding. So after a petition is filed, the patent owner then has 3 months to file a patent owner preliminary response. 3 months later, the board issues its institution decision, and then if it institutes, then it's the patent owner's turn again. The patent owner then has 3 months to file a patent owner response supported by expert testimony, and then 3 months later, and now we are a full 12 months from filing the petition, the petitioner finally gets to come back with a petitioner's reply. And so after a petition is filed, it has to withstand a couple of attacks by the patent owner and also pass muster for the board to institute on the grounds that were set forth in the petition. And I think in my experience and also in Eric's, sometimes up to 40% of the cost of an IPR proceeding can come during preparation of the petition. And so being able to recognize efficiencies and building upon strong opinion letters can be very helpful for companies preparing for these proceedings. Due diligence is also important because of the potential outcomes that may occur if a petition is not successful. For example, if the PTAB denies institution, typically there is no appeal. Also, if the PTAB does institute and then proceeds to a final written decision, and let's say that the claims are upheld as patentable, then petitioner estoppel can apply, which may prevent the party, the petitioner, from asserting those arguments or other arguments that reasonably could have been raised during the inter partes review in a district court litigation or in a litigation at the ITC. And so proper due diligence, building on a prior opinion letter, really may help avoid these negative possible outcomes, which can leave a petitioner in a relatively unfavorable position after an unfavorable IPR. So we do have some recent updates on IPR practice, and one of them is the new claim construction standard. This went into effect and is effective for petitions filed on or after November 13 of last year. So the old standard for claim construction was known as the broadest reasonable interpretation. And this was a standard that really has only applied before the U.S. Patent and Trademark Office. And the reason a broadest reasonable interpretation standard was used reflected a belief that patent owners could always amend the claims to narrow them and thereby avoid a broad interpretation. So it seems that it was intended to encourage parties to amend the claims to the extent necessary to get around the prior art. The new standard is based on the en banc Phillips case, and this is the same standard that is used in U.S. district courts and in the International Trade Commission. So what is this Phillips standard? What it refers to is the claim should be construed based on the ordinary and customary meaning of the claim as understood by one of ordinary skill in the art and the prosecution history pertaining to the patent. And so now that the same standard is being applied in district courts and in the ITC, claim construction issues are now becoming more directly applicable to IPRs. And so the USPTO has indicated that any prior claim construction findings of record in a district court proceeding or before the ITC, if that claim construction is brought into an IPR, a PGR, or a CBM, the board will be considering it. And so what is the strategic impact of this new claim construction standard? In general, I think it may be a small benefit to patent owners who are defending their patents in the PTAB. Because before the change, parties challenging unexpired patent in the USPTO could argue that the claim should be interpreted more broadly for unpatentability challenges than for infringement. And so the petitioner could argue that the patent was a very large target for a prior art attack in the PTAB, but then turn around in the district court and potentially argue that it really has a narrow claim scope for purposes of proving infringement. I don't think it necessarily turned out that way very often in practice, but there was a difference in the claim construction standards between district courts and the PTAB. Now, challengers must argue that the same scope for patent invalidity should apply as well as for infringement, because the same standard is appearing in both district court litigation and PTAB litigation. And so to handle claim construction issues in all of these different proceedings, I think it is very important now for petitioners to be consistent in the positions that they're taking, and also for patent owners. Because if a party is advancing one position in district court and another in an IPR, then the party will have those arguments used against them. If experts are taking inconsistent positions, they will be impeached with those other positions. We also have an update on patent owner motions to amend. The USPTO has been conducting for a while now a study on motions to amend, and they had an update back in September of 2018. And the reason they're conducting this study is shown on the slide, because out of 4,269 trials, you can see that only about 10% of these had a motion to amend filed. So motions to amend are relatively rare in IPR proceedings, and the USPTO has been trying to figure this out. Well, it doesn't take a genius to figure out why they're not a very popular option with patent owners, is because very few motions to amend are granted. You see that 90% of motions to amend that actually proceed to a decision on the substitute claims presented are denied, and only 10% are granted either in part or in whole. So doing the math, roughly only 1 out of 100 IPRs have really had any success with a motion to amend. So the numbers are very low, and the Federal Circuit and the director of the USPTO have remarked on this. The Federal Circuit, in its en banc Aqua Products case, noted that patent owners largely have been prevented from amending claims in the context of IPRs. It just hasn't been a very fruitful option. Also, the USPTO director at the 2018 AIPLA annual meeting remarked that the current amendment process in AIA proceedings is not working as intended. So what has the USPTO done about this? Well, less than 2 weeks ago, the PTAB instituted a new motion to amend pilot program. And this pilot program applies to all AIA proceedings, IPRs, CBMs, PGRs, that are instituted on or after March 15, 2019. So this ropes in cases that have been pending now for a while, and it will apply to proceedings based on the date of the board's institution decision. This program is expected to continue for about a year. It could be modified, terminated, or continued based on feedback and how parties and the board think that the program is working. But the purpose is to give patent owner a more realistic and meaningful opportunity with its motions to amend. And it has two options. First, the patent owner can pursue the current motion to amend practice, which basically means that they file a motion to amend at the same time that the patent owner response is due, and just proceed under the way the rules are currently in place. However, there are some due date extensions for replies and surreplies that are extended up to 6 weeks. The second option is the very interesting new development. And under the second option, a patent owner may request that the board provide preliminary guidance on proposed amended claims. And here, the board is supposed to provide a non-binding preliminary opinion on the patentability of the proposed amended claims. And this can either be in a written order, or it can be delivered to the parties orally, for example, over a conference call with the board and the parties. And then depending on the feedback that's received, the patent owner has a couple of options. If the patent owner receives good feedback from the board, then the patent owner may decide to stay the course with the amended claims as drafted and just file a patent owner reply. But if the patent owner has negative feedback, then the patent owner may want to adjust the amended claims and then has the opportunity to file a revised motion to amend. And so we have a slide here showing the schedule set forth in the pilot program. And what you can see is that on the left-hand side, after the institution decision, there's a 12-week period where the patent owner gets to file a patent owner response. It can also file a motion to amend. Then the petitioner has 12 weeks to file a reply and in opposition to the motion to amend. And then this is when the board has the opportunity to provide its preliminary guidance on the motion to amend if the patent owner requests it. Now, we'll assume in this case that the patent owner likes the feedback from the board, maybe indicating that the amended claims are likely to be found patentable. Then the patent owner can simply file a reply, and then the petitioner gets a surreply, and then 3 weeks later, the parties are already at the oral hearing, after which nothing really happens in the case while the board is formulating and writing its final written decision. We also have the schedule for the option where the patent owner decides to file a revised motion to amend. Again, we have the motion to amend being filed at the same time as the patent owner response. And then 12 weeks later, there's a petitioner reply and also an opposition to the motion to amend. Then the board provides its preliminary guidance on the motion to amend. And here we've assumed that the feedback may be negative, indicating that the amended claims might not be found patentable. And so the patent owner then has a few short weeks to prepare a revised motion to amend. Petitioner has 6 weeks to file its opposition to the revised motion to amend. And now we have an additional round of briefing where the patent owner gets a reply, has to be filed within 3 weeks, and then the petitioner gets a surreply after 3 weeks. And then there's only 1 week remaining until the oral hearing. So there's a very condensed schedule at the end of the proceeding. And this is a very condensed schedule because there is still discovery happening during this revised motion to amend process. Parties have the opportunity to provide new evidence, including declarations, with every paper except a surreply. And that means that there are very fast turnarounds in terms of putting witnesses up for depositions. And the board in its pilot program clearly expects the parties to work together, to be flexible, and to conduct these cross-examinations promptly. So with that, I believe we have reached the end of our presentation. I will turn it over to Ningling and ask if she has received comments from our listeners.
Yeah, thank you, Pierre and Eric, for the wonderful presentation. Very helpful, lots of information. Before we begin the question and answer portion of our event, I will ask the audience take a moment to complete the brief evaluation survey. As we strive to provide programs of value and continue improve our program, we would appreciate your input, which will guide us in planning future programs. So now let's do some questions from the audience. I get here several questions here for both of you. First, Eric, you mentioned during your presentation that during the litigation, it's helpful to rely on the opinion to defend against willful infringement, but at the same time may have certain concern for the waiver of opinion letter. The question is the timing. When you are during the litigation, when do you rely on the opinion letters?
All right. Thanks, Ningling. That's a very good question because the short answer is you don't want to rely upon the opinion letter until you have to. Typically, your lawyers may try to have damages in a case separated out from liability issues. So if they do that, that's called bifurcating the case. In that instance, you wouldn't have to have the opinion letter be subject to discovery at all when liability is determined. It's only in the damages phase that it would be important. So therefore, you would wait until the damages phase to produce the opinion letter. In other courts, for instance, in Delaware, I'm aware of a case right now that our firm's involved in where the opposing party asked us as a defendant if we were going to rely upon an opinion letter, and they asked us in an interrogatory. So an interrogatory is something that must be answered during the fact discovery period. That was approximately 12 months after the case had started, so we had 12 months essentially to determine whether or not to rely upon that opinion letter. We did not rely upon it in this particular case, but in other cases, we have relied upon opinion letters. So it really depends how close the issues are 1 year into fact discovery in terms of claim construction. Maybe the court gave a very favorable claim construction, so there are less questions about whether you're going to actually lose at the end of the day. Maybe some other things have happened. So you really want to give yourself as much time as you can before you have to rely upon an opinion letter.
Okay, great. Pierre, one question for you. When you did your presentation, you mentioned that it's very important that to keep the consistent claim constructions for PTAB proceedings, opinions, and litigation. Can you let us know why you think that's so critical?
Yeah, certainly. So consider a situation where a party is in litigation and they're defending against infringement, and their position is based on a claim construction, for example, where a party is saying that it doesn't infringe because a claim should be construed one way, or the asserted patent is invalid because it should be construed a particular way. Now, let's say that the party has to rely on its opinion letter to defend against allegations of willfulness. And if the reasonable belief of invalidity or non-infringement was based on another claim construction, it may put the veracity or reliability of that opinion letter into some doubt, and it may diminish the party's chances of actually successfully relying on the opinion letter to avoid willful infringement. And this can also come into play in IPR proceedings. For example, when a party has decided to use its opinion letter in litigation, in that situation, the opinion letter is no longer protected by the attorney-client privilege. And so if a party wants to advance arguments that are contrary to the opinion letter, for example, on claim construction, then arguably the party may need to disclose that opinion letter as inconsistent information because it is contrary to positions being taken before the PTAB and the IPR.
Okay, great. I think we still have a couple minutes, and I would like to ask Eric one more question because several attendees actually asked this question. I think it's a good. You mentioned earlier that the opinion letter is very important. So the question is that should you use the different counsels for opinions letters and for litigation?
So I wanted to jump in on Pierre's previous answer real quickly. You want to be consistent because the other side is going to try to impeach you and make you look like you'll say anything. You'll say the claims are broad in the IPR and they're narrow in the litigation for infringement and things like that. So you need to be consistent across the many fronts so that you cut off that argument. As for separate counsel, it depends what kind of case it is. If it's an ITC case, you don't need separate counsel. If it's an IPR case, you don't need separate counsel. If it's definitely something that's going to go to a jury, perhaps in the Eastern District of Texas, for $300 million, then you might want to get separate counsel because everything has to be kind of really carefully managed in big cases like that.
Okay, got it. Thank you both very much for your wonderful presentation today. I think also I want to thank all our attendees for attending today's Asia Series webcast, Practical Advice on U.S. Patent Law Issues, Opinion Letters, and IPR Filings. This presentation will be available on demand in the next week, so please look for email from us with the access link. And we're also going to try our best to answer your questions, because I noted that we have so many questions not answered today because of the time constraint here. But we will do our best to answer your questions later by email. And this concludes today's Finnegan's webcast. Thank you for participating. We look forward to having you again in our next series. Thanks.